next session will be the Federal Trade Commission. It'll be given by Aniela Szymanski, certified information privacy professional, an experienced attorney licensed in the great state of California and Nevada, and served on several federal jurisdictions and agencies. She's helped numerous small businesses with their legal and operational needs and has years of experience working with the Department of Defense, Department of Veteran Affairs, and the Federal Trade Commission. Aniela has worked as a lobbyist in Washington, D.C., was a professor at William and Mary School, and has represented hundreds of individual clients before administrative agencies and various courts. She's a graduate of the University of Nevada, Las Vegas, University of San Francisco School of Law, Marine Corps University, and the Naval Justice Course. Aniela served over 20 years in the United States Marine Corps, between active and reserve time as a judge, advocate, and civil affairs officer. So it is my pleasure to introduce Aniela Szymanski. It's all yours, Aniela.
Thanks so much for that kind introduction, Vince. And I appreciate everybody being here for this exciting session on the Federal Trade Commission. I'm going to share my slides. So just a moment while I get those up and running. This is me and my contact information. I am with RNT Professional Services as the Chief Privacy Officer, which basically means I spend a lot of time being paranoid about my privacy and everybody else's privacy. Once you're in the industry, it's like you can't unsee some things. So this is an overview of what we will be discussing today. First, I'm going to discuss a little bit about the Federal Trade Commission's jurisdiction and authorities, some of their recent enforcement actions, and how to stay off the FTC's radar. The FTC has been around since 1914, so it's definitely not a new organization. And their mission is to protect consumers and promote competition. So they've done a lot of work in antitrust and making sure that consumers have healthy competition. But recently, they have been a lot more interested in consumer privacy and data security than they have been historically. And this means that they've been looking at how to enforce federal laws and ensure that consumer privacy is not taken advantage of by industry. They have other areas of enforcement too, like the Fair Credit Reporting Act, Children's Privacy, and the Gramm-Leach-Bliley Act, but I'm going to just focus on the consumer privacy and data security elements. How the Federal Trade Commission works is that anyone can file a complaint. Any consumer, anybody who thinks that they've been wronged by a company can file a complaint with the FTC through their online portal or through their hotline. And those complaints get aggregated into something called the Consumer Sentinel. And the Consumer Sentinel is a database that's shared by multiple law enforcement agencies, to include the FBI and state attorney general offices. So it is a centralized database of consumer complaints that several agencies can draw from. Then if the FTC decides that a complaint is worthy of action, then they will initiate an investigation. Sometimes these investigations can take years, depending on what they're investigating and the extent of it. Then the commissioners, the FTC commissioners, vote on whether they want to bring a case against the offender. And the vote is based on whether they have reason to believe that violations have occurred or are about to occur. So they need not actually have been violations of the law yet, but they can even bring actions if they think that somebody is about to violate the law. Then they will bring their action in federal court, and they will seek injunctions to stop companies from doing certain things and damages. Some statutes allow for monetary damages. Sometimes they seek equitable relief, which means if you've gained $100 million from your illegal activity, then they'll seek to recover that $100 million. So it just depends on the type of action that they bring. Sometimes these will be in conjunction with the state attorney general office. Sometimes they'll be in conjunction with other agencies, but most of the time, the FTC acts alone. And more often than not, these legal actions end in settlements. And if a settlement is reached with the Federal Trade Commission, there is generally a 10-year compliance period that they ask for. And that means that you will be monitored for 10 years to ensure that you are complying with that settlement agreement. And often that means you have to pay for the settlement administration costs. In actuality, what that means is you have to pay a law firm to monitor whether you're complying with the settlement, and they will have lawyers reviewing what you're doing, how you're doing it, and whether it complies with the settlement. So once the FTC has their hooks in you with a settlement agreement, they're not going to let go for a long time. It's going to be at least 10 years that you're not going to have them around. Alternatively, if the FTC decides they don't want to bring an actual lawsuit, they can also issue warning letters. And you can see some of their warning letters on their website. And basically, it warns companies to stop what they're doing because they have reason to believe that their activities are illegal or getting close to illegal. And then they threaten to sue if the warning letters are not complied with. So they have several avenues of influencing behavior in the FTC. This is from their Consumer Sentinel data book for last year, 2020. Like I said, anybody can make a complaint. In 2020, they got 4.7 million complaints, and 2.2 million of those were about frauds. The top three categories, as you can see, were identity theft, imposter scams, and online shopping and negative review complaints. So because the FTC gets 4.7 million complaints, it's unlikely that they're going to take up a case unless it has some significant impact. And I'll talk about a couple of those later and how they ended up being on FTC's radar. So there are three regulations that I want to discuss specifically in this presentation. One is the CAN spam rule. The second is disposal of consumer information and records. And the third is consumer privacy promises and how the FTC acts on those under their authority for deceptive and misleading consumer information. So first, let's talk about the CAN spam rule. And the reason that I wanted to bring this up is because it technically is a rule about advertising, but it is something that a lot of businesses don't even realize applies to them. So it's important to keep this rule in mind if you're a business, because it's very easy to violate, which I'll discuss in a minute. And also, it has a privacy element in it because the reason that the FTC gets interested in cases that violate the CAN spam rule generally relate to to consumers feeling that their privacy is being invaded by these unwanted and what they consider unauthorized emails that they're receiving. So it often accompanies CAN spam rule violations, often accompany other violations with within FTC's jurisdiction and can be an easy one for FTC to add on as another offense when they're investigating related misconduct, sort of like tax evasion. If they can't get you on a substantive criminal offense, the government can usually get somebody on tax evasion. So let me talk about how CAN spam can apply to you if you are a business. It is a rule that applies to all commercial messages, not just bulk emails. And I think this is where people get confused on this rule and whether it applies to them. It can be one individual email. It doesn't have to be a spam bulk email. It can be just one, because it's any electronic mail message that has the primary purpose of commercial advertisement or promotion. So even if you send one email and it has the primary purpose of advertising or promotion of your product or service, that CAN spam can apply to it. And if you violate it, it could have very real consequences for your business. There's also, importantly, no business to business exception. So even if you're sending your email to another business, then it can be violative of CAN spam. It doesn't mean that you have to send it to individuals or potential individual customers. It can be business to business emails as well. So CAN spam requires that all of your emails have accurate header information and that they don't use deceptive subject lines, and that you have to include that this is an advertisement. This is a really interesting point because there's no specific way to identify something as an advertisement. They leave it up to the sender how to identify it as an advertisement, but it has to be clear that it is. It has to include a physical postal address and has to include a way to opt out of future emails. And US law doesn't prohibit sending an initial commercial email, even if you don't have the receiver's consent. So basically it's like you get a one freebie. So you don't have to have you don't have to have consent to send an initial commercial email, but it has to comply with all of these elements. This also applies to messages through social media. So for instance, some companies will send through Facebook Instant Messenger or through Instagram direct message messages about their products, like, we're running a special, buy two, get one free, and you'll get that message in your instant messenger platform. The CAN spam rules apply to those as well. So the other interesting point about CAN spam is that it also applies to mobile messages. So text messages. I'm sure everybody has received these kinds of messages that you wonder, how is somebody getting my cell phone number to text message me information about things that I have no idea? On top of the fact that this could be a virus scam, it also could be violating CAN spam. So you have to have permission before sending a mobile message separate from emails. Emails, you can send one email unsolicited. Text message, you have to have prior permission. There's no one freebie rule like there is with commercial emails. So the sender has to have your permission before sending these. And I'm sure that, like I said, many of us have received ones that we don't remember giving anybody permission to send to us. So that would be considered a violation of CAN spam. And CAN spam has steep violations, $43,792 per violation, which is per message sent, either per text message or per email message. So the FTC does like to prosecute these because they get a lot back in damages, because generally they can find that offenders sent many, many, many hundreds of thousands, sometimes, messages. And in 2019, the FTC actually entered into a $1.5 million settlement with a company, a marketing company that used false celebrity endorsements and also used manufactured news stories to promote a work from home service that consumers could buy into. So individuals were receiving emails of this work from home service, buy into our work from home program and make tons of money. And they had these false, misleading subject lines and content. So on the left, you can see, work at home jobs as seen on ABC, Fox News, CNN, NBC. None of those were actually true. The second one in the middle, you can see it looks like a legitimate CNN article that they try to get people to click through on. And on the right-hand side, Forbes, an alleged Mark Cuban article. So these were found to violate CAN-SPAM because they did not contain information that was accurate in the subject lines, in the content, and the header information. And although the FTC settled this case for $1.5 million, they actually imposed an $11.5 million fine on the company, but found that the company could not afford the $11.5 million fine. So they reduced it to $1.5 million. This case was EFFEN ads, EFFEN ads, and it was prosecuted in the U.S. District Court in Utah in 2019. So under CAN-SPAM, it's not only the FTC that can sue, but it also creates a right of action for internet access service providers to sue, and state attorneys general can sue on behalf of residents of their state. So while it doesn't create a cause of action for private individuals to sue, the internet access service providers can sue. And that's interesting because that's a really vague term, and not even the courts have been able to decide what exactly internet access service provider means. But based on a case out of the Ninth Circuit Court of Appeals, it definitely means something more than providing email accounts. So they found that just providing email accounts is not enough to consider yourself an internet access service provider. And they speculated that there should be some hardware element to it. So we've yet to see what exactly fits that definition. And there actually has to be some harm. They have to be harmed in some way, although reputational damage could be sufficient. So it's really difficult to understand how anybody other than the FTC and a state attorney general is going to have ability to enforce this. But it's out there. You have to be very careful of what you are doing when you're sending these messages, because you can very easily violate this CAN-SPAM rule. And then the FTC is concerned you're imposing on people's privacy, sending them unsolicited messages on text, and not allowing them to really have their email free of these spam emails. So you don't want to be stepping on your own toes there. Let's talk a little bit about disposal of consumer information and records. The FTC had the first federal disposal of information rule, but states have state rules also. So there are some state statutes that discuss disposal information, but this is the first federal rule to discuss disposal of information. And it applies to businesses and individuals who maintain or possess consumer reports and records for a business purpose. And it covers disposing sensitive information, which basically is all information that is generally referred to as personally identifiable information. So you'll have to think whether you or your company have records that fall into this realm. And more often than not, I find that companies do, because if you're collecting information for processing payments, running credit reports, doing background checks on employees, you likely have information that's covered by this disposal rule. So what does the disposal rule not include? It does not include information that does not identify an individual, but could be, so that could be blind data or information that if aggregated could identify individuals, but aggregate information the FTC found was not enough. It would have to be information that actually in and of itself identified an individual. In 2016, the FTC considered whether to expand the disposal rule to cover information like this and decided not to. So it'll be up for another review in about 5 years because the FTC is required to do 10-year reviews of their rules. So I'll be interested to see if this disposal rule changes as information and access to information has changed and how social media and information can be aggregated to really build a profile of people and whether they'll reconsider whether aggregated information and blind data should also be covered by the disposal rule. But in the meantime, how are you to dispose of this information if you have it and not violate the FTC rules? These are examples given in the actual rule itself. So these are not all-inclusive, but they're just examples given in FTC's rule. Burning, pulverizing, shredding, erasure of electronic media, but you should be looking towards authoritative sources like NIST to determine what the best industry practices are, because the FTC is going to be looking at those as well for industry practices. So I'm going to talk a little bit about a case that that had an element of not disposing properly of personally identifying information. And this was a 2020 case against a company, the FTC brought against a company called Skymed. Skymed is an emergency travel services company. And what they are is sort of like a concierge medical travel. If you can buy a membership to Skymed, and if you're traveling overseas and you have a medical emergency, you can contact Skymed and they'll basically get you medevaced, get you transported to emergency medical services or get you transported back home. And it is supposedly to create, a sense of security when you travel, that if you have a medical problem, you'll be covered. So Skymed actually required its members to disclose all kinds of medical information in order to be members of Skymed. And then they left that information unsecured in a cloud database containing over 130,000 records that could be accessed by anyone on the internet and in plain text. So in other words, not encrypted in any way or disaggregated in any way. So it really compromised a huge amount of people's personal information and medical data. And then when this was discovered by, as you can see, it was exposed by a security researcher. When this was discovered, Skymed actually lied to its members and said that it had fixed the problem when it hadn't. So Skymed was sued by the Federal Trade Commission and in December of 2020 entered into a settlement. And this was an interesting settlement because the FTC actually mandated an information security program. And in the settlement, Skymed has to undergo biennial assessments to identify whether there are any risks remaining, what efforts they're making to monitor release of information, and examine the effectiveness of their overall program. And like I said at the beginning of this presentation, once FTC gets their settlement hooks into you, they're going to be breathing down your neck for 10 years. So basically, at least for the next 10 years, Skymed is going to have this very highly monitored information security program. And this was unique for the FTC because it did not historically require information security programs as terms of settlements. So now we see the FTC is moving into sort of the security management oversight business almost to force companies to comply with what FTC thinks are the best ways to protect consumers' private information. So let's talk a little bit about privacy policies. Also recently, just as I mentioned, recent interesting developments in data protection by FTC. FTC has become very interested in what companies are promising consumers in their privacy policies, what you actually have written in your privacy policies, and how you're following through on those policies. And in some cases, it's had some very interesting enforcement actions against companies that did not comply with their own privacy policies. So one recent case was against a company called Everalbum. And Everalbum it's still around, an app where users can upload photographs and then share them with friends and then keep them sort of like in an online album. Well, users according to Everalbum's privacy policy, users could choose not to have facial recognition applied to their images. Well, why would anybody want facial recognition applied to their images? Everalbum had this feature that it could use facial recognition on your photos and then automatically connect those photos with your friends. So if Daniela and Vince are friends in Everalbum, if there's a photo of me with Vince, it would facially recognize Vince and automatically include that photo in his album. So maybe some people would have wanted that feature. I don't know. But it said that people could choose to opt out of that, but then it did not provide the actual opt-out option to all users. It actually only provided opt-out options to users in 4 states. So it was not, if you were not in one of those 4 states, you couldn't opt out of the facial recognition feature. Their privacy policy also said that users could delete their photos from their account, but in actuality, those photos were retained indefinitely, even if a user deleted their entire account. So if I deleted my entire Everalbum account and said, I don't want to use your service anymore, Everalbum actually retained the photos in violation of their own privacy policy. The reason this is really interesting, and the reason that this was really interesting to the Federal Trade Commission, is because Everalbum also operates a business called Paravision, which is still around. And Paravision develops and markets facial recognition technology to clients in the security and air travel industries. So the company was using the facial recognition technology that was being enhanced by Everalbum and then using that in their Paravision products that they were selling to security in the air travel industries. Interesting, because Everalbum was a free app, but people didn't know that they actually were being used to create a different product that this company was then selling in other industries. So the FTC did not like that, and they sued Everalbum. And part of the lawsuit is lawsuit settlement was that they required Everalbum and Paravision to actually delete the technology off of Everalbum. And so this was a unique remedy that the FTC used for, I think, the first time in this case, which is that they actually required the company to delete the technology instead of just deleting the photos or the facial recognition data. They actually required them to completely remove that technology. So FTC moving into different remedies as well, we see with these new cases involving privacy. So the next one that I wanted to discuss is an FTC action against a company called Flow Health. And Flow Health has an app that helps women track their periods and fertility on their mobile device. Well, they promised not to share that data, but they did. They shared it with Facebook, Google Analytics, Google Fabric, AppsFlyer, Flurry, and they were using this information. These other parties like Facebook were using this information for marketing purposes. And so they would get notified of an app event. So say I'm using this app and then I note in the app that I had a positive pregnancy test. That information would then be an app event that was transferred to these third parties for marketing purposes. So then Facebook would know Aniela is pregnant and then use it for marketing to me. So I'm sure that a lot of people did not expect that to happen when they were using this app, and it was in violation of their own privacy terms. So they also, interesting point, they also did not limit how these third parties could use the information. So they just sort of were saying, oh, here's the information, do what you want with it, in violation of the privacy terms of the user's agreement. So these are cases where the FTC actually said, we are looking at what you're promising and whether you're following through on it, and finding some really bad offenses of companies not following their own privacy policies. So how do you stay off the FTC's radar so you don't become one of these cases? It's really simple. Just be a good steward of data. Know your own privacy policies and comply with them. Have a privacy officer that can help you do that. Don't expect that people in your company are going to know to keep an eye on this unless you make it an intentional practice by having somebody assign that responsibility. Also, dispose of data responsibly. Don't leave it on the cloud. Don't keep it unencrypted. Delete it properly. Be careful of your communications and how things are worded and presented, and don't mislead consumers. Because if you, as soon as FTC starts seeing something that they consider misleading, they're going to start digging and digging and digging until they find something. So those are my recommendations, and I hope that we have some questions that